Hi, everyone. Thanks so much for joining us. Today, you are attending our webinar on the new employee share scheme disclosure exemptions. My name is Sophie and I'm a practice leader in LegalVision's startup and capital raising team. And I'm joined today by my colleague Zoe, who is a lawyer in our startups and capital raising team as well. Before we begin, a couple of quick housekeeping items. So after the webinar, you'll be emailed a copy of the recording as well as the slides. While we're speaking, you can submit your questions in the chat box and we'll discuss them in the Q&A section at the end. And then we'd also really appreciate as well if you could complete the survey after the webinar is completed so we can see the feedback that you have. And also, all attendees today are also eligible to receive a free consultation with us to discuss how we can help you with your ESOP or any of your other legal needs. To request a free consultation, provide us with your contact details in the survey that appears at the end of this webinar. So today, we will be discussing what are the disclosure rules and why do they matter in relation to ESOPs, what the disclosure exemptions are, what types of offers are eligible for the new disclosure exemptions, what needs to be given on an ESOP offer, what needs to be given on exercise of options, and then also how trusts and contribution plans and loan plans relate to these new disclosure rules. And then we'll also have a section at the end to answer any questions that you have along the way. I'll now kick off the content portion of our webinar and set the scene for why the disclosure rules matter in relation to ESOPs. So most startups utilise some form of employee equity plan to incentivise staff and align interests of the employees with that of the business. Something that startups often forget is that issuing equity, whether it be to employees or investors, is regulated under the Corporations Act. And so there are restrictions that apply, especially to private companies, which most startups are. And these rules affect the type of people and also the number of people that startups can issue equity to. In relation to ESOPs, this won't be a huge concern in the early days of a startup when you only have a handful of employees, but the disclosure rules are important for startups to be aware of as the company grows and the number of people participating in the company's ESOP increases. Firstly, we'll explain what the disclosure rules are so you can understand why it's important to consider which exemptions apply when you're making ESOP offers. And then the bulk of this presentation will be focused on the new disclosure exemptions which were introduced into law last year. These changes were aimed at reducing red tape for larger startups who can no longer rely on simpler exemptions. These changes make it easier for startups with a larger number of staff to comply with the disclosure rules, provided that the offers are structured in a way that still protects employees and provides them with the necessary information to make an informed decision to take equity in a company. I'll now throw to Zoe, who will explain in greater detail what the disclosure rules are that apply to companies and what they actually require.
Thank you, Sophie. So under the Corporations Act, you must provide certain disclosure documents to people who are issued securities in your company, unless an exemption applies, which Sophie touched on. The disclosure rules are relevant to consider in the context of ESOPs because the company will be issuing securities whenever it makes an offer to employees under the relevant plan. The securities will either be options or shares, depending on the structure of your plan. The purpose of the disclosure rules is to ensure that people who are investing into your company are aware of the risks that are involved with that investment. And this is why disclosure documents need to be provided to employees if an exemption doesn't apply. And those disclosure documents need to include information about your company to assist with determining the nature of the relevant investment. For example, they include information about how the company intends to generate income and the risks involved in the company's business that could impact on the value of the securities that are held by the employees. Most startups aren't able to comply with the requirement to provide a disclosure document, like an offer information statement, or you may have heard of a prospectus before. And that's because of the rigorous compliance requirements and the large expense involved in preparing those documents. So ideally, startups will be wanting to rely on an exemption from those requirements. The most common exemptions from the disclosure requirements in the context of ESOPs are on the slide here. Firstly is the small scale offerings exemption. This exemption applies if the company makes an offer of securities to 20 or fewer people in a rolling 12-month period. This is essentially a safe harbor threshold to ensure that smaller companies don't need to prepare those onerous disclosure documents. And then the second relevant exemption is the senior manager exemption. And this is an exemption that applies to offers that are made to senior managers in your company. And the policy rationale behind this exemption is that those more senior people should already know the information about the company that would otherwise be included in those disclosure documents. And just a note as well that the 20-person limit for the purpose of the small scale offerings exemption excludes any offers that are made to those senior managers. The other relevant exemption to consider is the topic of this webinar. The new regime that was introduced in October last year. For the purpose of this webinar, we'll refer to those new rules as the new ESOP disclosure exemptions or the new ESOP disclosure regime. However, it's important to note upfront that although the new regime applies to exempt companies from providing the usual more onerous disclosure documents like prospectuses, certain information still needs to be provided to ESOP employees if you're seeking to rely on this new disclosure regime. And for this reason, it's actually still in the company's interest to rely on those existing small-scale offering or senior manager exemptions that I mentioned before, because if you can rely on those, then no additional information needs to be provided to those employees. The new ESOP disclosure regime is therefore going to be most relevant to consider if you can't rely on those exemptions, or if you expect that you may not be able to rely on those exemptions in the future. The new ESOP regime is also relevant to consider if you've previously relied on what are called the ASIC class orders, because those class orders can no longer be relied on from 1 April. For the purpose of this webinar, we'll be discussing the new ESOP disclosure regime in the context of startup option plans, which have an exercise price payable. Different requirements apply for option plans with zero exercise price, for listed companies, and for companies that have share schemes rather than option plans. And now I'll hand back to Sophie to discuss what offers are eligible.
Yes, so in considering the types of eligible offers that you can make in a way that's compliant with these new disclosure rules. So firstly, the people that can participate in your ESOP must fall within specific classes of persons, which includes directors of the company, employees of the company, and other service providers. And secondly, the interests that employees receive must be what are called ESS interests, which is a defined term in the legislation. However, to put it simply, most option plans will satisfy this requirement as you'll be issuing options over ordinary shares, and that class of security falls within the definition of an ESS interest. The terms of your startup ESOP, provided that they're fairly standard terms, should already meet these two requirements. The next requirement is called the issue cap requirement, which puts a limit on the number of options that you can issue in connection with your ESOP to be able to rely on these new disclosure rules. To put it simply, the relevant offer combined with offers in the previous 3 years must not result in the company issuing shares that are greater than 20% of the company's total number of issued shares. Because of this issue cap requirement, you'll need to keep track of the offers that you're making under your ESOP and make sure that the cap is not breached. it is possible to increase the issue cap above 20% of your shares by including a higher percentage in your company's constitution, if you did want to amend your constitution to achieve that. The last requirement that I'll talk about in this section is called the monetary cap requirement, which limits the amount that each individual employee can pay to the company to participate in the company's ESOP. The purpose of the monetary cap is to ensure that the company is using its ESOP for the intended purpose, which is to incentivize people who work for the business, and ensure that you're not using these new rules as a way of the company to raise capital. To comply with the monetary cap, the amount that an employee is allowed to pay under a compliant offer for options in a 12-month period must not exceed $30,000 plus 70% of the value of any dividends that that employee received in connection with the ESOP during that 12-month period, plus 70% of any cash bonuses that that employee received in that 12-month period. And that yearly $30,000 cap can be accrued in relation to unexercised options over 5 years. So you can spread out the offers to achieve a maximum payment of $150,000 over 5 years. Now, in terms of what needs to be given to employees to comply with these new rules at the time of offer, firstly, the offer letter needs to contain a statement that the offer is made under Division 1A of Part 7.12 of the Corporations Act, which is where these new rules are contained. And the offer letter itself that is provided to employees must include a number of specific things in order to comply with these rules. And so that includes the terms of the offer itself, general information about the risks of acquiring and holding securities in the company, a statement that any advice given by the company in relation to this offer does not take into account the personal circumstances of the employee, their objectives, financial situations, or personal needs, must include a suggestion that the employee obtains advice in relation to the offer. It must state the period that the offer may be accepted by the employee, which has to be a period that starts at least 14 days after these offer information is provided to the employee. The offer letter must contain a statement that the options may not have any value and that the value of the options will depend on future events for the company that may not occur. The offer letter needs to contain a description of the rights attached to the shares that will be received by the employee upon exercise of their options. And if you are issuing shares that are different from ordinary shares, you have to explain how they're different. And lastly, the offer letter has to include a statement that the options can't be exercised unless the company provides to the employee a set of simplified disclosure materials, which we'll discuss next, and that those disclosure materials have to be provided at least 14 days before the employee has the right to exercise the option.
Thanks, Zoe. So, as mentioned at the start of this presentation, we're focusing on the requirements that apply to option plans with an exercise price. So that's an option plan where the employee needs to pay something to exercise their option and therefore be issued shares in the company. One key point of difference we see between option plans is the time at which the options can be exercised by employees. The two most common points of exercise are either once the options have vested or when an exit event occurs, for example, an IPO. Some companies also allow their employees to exercise their options when they leave the business. The point at which an option becomes exercisable under the ESOP is important to consider in the context of the new disclosure regime, because this is the point at which certain supporting information needs to be provided to the employee. That information is financial information, valuation information, and a statement about the solvency of the company. So first, the financial information. The company needs to provide the employee with a balance sheet and a profit and loss statement that's prepared in accordance with accounting standards. However, if your company is required to lodge a financial report with ASIC under the Corporations Act, then this is the financial information that needs to be provided to the employee. And the relevant report will be the report for the most recent financial year. In relation to the valuation information, the company needs to provide information about the valuation of the underlying shares over which the option has been granted. This will usually be a valuation performed by the company's CFO or a qualified valuer. And your tax advisor will need to confirm how the valuation should be performed in a manner that complies with the relevant tax law. And then finally, solvency statement is just a statement that the company is solvent at the relevant time. In terms of the time that the information needs to be provided, the legislation sets out that the supporting information must be provided 14 days before the option becomes exercisable. And this can be really difficult to manage if your options can be exercised whenever they're vested, which can be multiple times a year if you have a large number of employees. For this reason, you should consider whether to limit the dates on which the options become exercisable under your ESOP by either nominating a specific exercise period each year. For example, employees could exercise within a 1-month period at the end of a financial year, or using an ESOP that only allows exercise upon an exit event rather than exercise when those options vest. And next, we'll briefly touch on the requirements in relation to trusts and loans. If your ESOP utilizes a trust, for example, some common trusts are employee share trusts or bear trusts through which employee shares are held, then certain other requirements also need to be met in relation to that trust arrangement. And it will be necessary to ensure that the terms of the trust deed for the relevant trust meet certain requirements under the Act, including limitations on the activities that the trustee can undertake and the types of fees that the trustee is able to charge. The employees also need to be able to access the terms of the relevant trust deed. And if you help employees acquire securities under your ESOP by, for example, providing a loan or allowing salary sacrifice arrangements, then other requirements also need to be met. For example, the loan needs to be a zero interest loan. Please reach out to us if you intend to rely on the new disclosure regime and your plan has these features so that we can provide some more specific guidance on those requirements. And that concludes the main part of our webinar. You might find our publication useful, the Employee Share Schemes Guide, which you can access using the handout section in your webinar panel. We also have an upcoming event that could be of interest to you, which will be on the slide in a second. Selling a Business, How to Undertake Due Diligence, which is on Thursday, 13 April. We're going to answer any questions that you have shortly, but while you submit them, we'll take a minute to tell you about our membership. LegalVision's membership is a cost-effective alternative to the expensive hourly rates you experience with other law firms. For an affordable monthly fee, you receive cost certainty and all-inclusive legal services, including unlimited document review, including drafting, amending, and reviewing documents, such as business contracts and commercial leases, unlimited advice consultations with our team of over 100 specialist lawyers, including business structuring, employment, disputes, and more, and unlimited domestic trademark registration. LegalVision membership is like having your own in-house counsel. We'll take care of the business as usual legal work so you can focus on running your business. And if you are an in-house counsel, our membership is a cost-effective solution for outsourcing additional legal work. To learn more about how our membership can help you, please feel free to request a free consultation when the survey appears at the end of this webinar. And now we will turn to answering some of the questions that you had.
Yes, so just having a look at some of the questions that have been submitted. The first one, which I'm happy to talk about, is if a company has granted options to an employee in a manner that wasn't under these new rules, is it possible to revise that offer, and can you replace the original offer with a new offer that complies with these rules? And the answer is, unfortunately, you can't do it that way. And the reason why is because these disclosure rules relate to the type of information that you're making at the time of the offer. And so if you've made the offer, it's been accepted and the options have been granted, then effectively that transaction has already occurred. And so if that transaction was done in a manner that wasn't compliant with these rules, then there's really nothing that you can do about it at that stage. You just need to be conscious of this in relation to future offers that you make, and thinking about what exemptions might apply in relation to your future offers.
Perfect. I'm happy to take a question as well. So we have a question here about how taxation works if you don't use the startup tax exemption. So we haven't actually touched on the startup tax concession in this presentation, but broadly it's really beneficial for startups to comply with that, because it essentially defers the taxing point for employees until the point at which they can actually fund the tax payment that they need to make, because they get the payout in relation to their options. So how it works if you don't rely on the startup exemption or can't comply with the relevant requirements will essentially depend on the structure of your plan. And obviously we aren't tax lawyers, not specialist tax lawyers, so we can't necessarily set out all of the different tax implications of relevant structures. But yeah, it's just to be aware that tax is a very relevant consideration when you're structuring your plan, and you should be seeking tax advice on that.
I'll talk to the next question that we have, which is, what are the ESOP disclosure relief rules if you're approaching more than 20 employees or contractor grants within 12 months? So with this one, I think that, there's a few things to think through. The first one would be to consider whether or not any of those existing grants that you made within that 12-month period, or any of the imminent grants that you want to make, will be to people that you can classify as senior managers because they're involved in the decision making of the business. If so, then that essentially reduces the number of people that fall within that 20-person cap, because that operates as its own exemption. So if you can do that to reduce the number, then that would be really helpful. The second thing to think about is, because that 20-person rule applies in any rolling 12-month period, you can also consider whether or not it's possible to defer the next portion of option grants, or spread them out sufficiently enough that when you actually work it out over any 12-month period, you're still compliant within the 20-person cap in any 12-month period. So you can do it that way. If you're not making too many offers, you could space them out to still comply with the rules. And then thirdly, if neither of those options are realistic and you do just have to make a large number of offers within a given 12-month period, then that's when you'd be seeking to rely on these new rules. And as we've discussed, that will involve a process of updating the type of documents that you're providing at the time of offer, making sure that your offer letters contain the statements that are required by these new rules, and then also being conscious of the simplified disclosure documents, including those that financial and valuation information that Zoe touched on, and ensuring that you've got systems in place so that you can provide that information at the right time before employees have the right to exercise.
Perfect. There's also a question here around whether the $30,000 monetary cap means a cap on the amount paid by the employee when exercising their option. So the cap is in relation to the amount that the employee needs to actually pay. So yes, it's the amount that the employee will need to pay for the exercise price at the point of exercise. That's how you're considering what the whether you comply with the monetary cap.
And then just to follow on again on that 20-person exemption, which, as we mentioned, lots of people do rely on. The question is, does that refer to full-time employees? Does it apply to overseas employees? And so that 20-person rule applies to any, it can apply to offers that you make in Australia. So it doesn't really matter what class of person it is, whether they're a full-time employee, part-time employee, contractor, or advisor or director. If it's an offer made to someone in Australia, then you can rely on those rules. It doesn't really relate to overseas employees because these disclosure rules in general only apply to offers that are made in Australia, and so there would be different rules that apply to overseas employees, which if you're going to be making a large number of overseas offers, then it would be good as well to speak to your foreign lawyers to understand if there are any similar restrictions that you need to be mindful in that jurisdiction. Just having another look. Yeah, so there's another question about timing as well. So if a company has an ESOP program already underway, then do these rules apply to exercise of existing option holders or just options being issued from now? And it's the latter. So it only applies to new offers that you're making that you want to comply with these rules. And so if you have any existing option holders that you made grants to under different rules, like the senior manager exemption or the 2012 exemption, then you don't really need to worry about this in the context of those offers. Those simplified disclosure materials are not rules that will apply to them when they go to exercise, because it only relates to these new rules and new offers that you're making under these new rules.
There's also just a general question about ESOP pools and reserving options for future employees. So the question is, do we have to offer all of the options at once to current employees, or can we reserve options for future employees? And the way that these ESOPs are usually structured is that you'll have kind of like an allocated pool of options that are there for issuing to current and future employees, but obviously you'll be wanting to keep track of the number of options that you're issuing to make sure that you're not issuing above the total reserved pool, which commonly we'll see as around 10% of the issued securities in the company. So to answer that question, yes, you are reserving options for future employees as well as issuing them to current employees.
There's also a question around the timing of providing those additional disclosure documents like the valuation information and the statement of solvency. So yes, that information, that valuation information, the financial information, the solvency statement only needs to be provided at least 14 days before the right to exercise. So you still need to be mindful of this in the context of employees who might not actually want to exercise, because as long as they have the right to exercise, then you need to be providing that information before that right crystallizes effectively. And so you don't need to provide that information at the time that you're making the original offer on day one, but as we mentioned, in the offer letter itself, you need to ensure that the offer letter contains certain statements, and one of the statements is letting the employees know up front that before they're allowed to exercise, the company is obliged to provide them with that information. So you don't need to provide the information at that point, but the offer letter needs to contain a statement saying that you will when it becomes relevant at the time of exercise.
There's also a question here about, we mentioned that you can no longer require on the ASIC class orders, and the question is wondering which class orders those are, which is fair enough. So those are the class orders that were in some ways similar to the new ESS disclosure regime. There are some similarities, but the intention was to make this regime easier to comply with, because there was feedback that those class orders were really difficult to comply with and not very practical. And I believe they were class orders 14/1000 and 14/1001. If that's any help, I don't know if they have specific names, but those are the ones that you can't rely on from 1 April anymore. For new offers after 1 April, sorry. So for offers before 1 April, that's still fine.
So there's also a question about how companies should be thinking about this if they've got particular employees where they might fall within more than one exemption. So for example, if you're making an offer to someone who's classified as a senior manager, do you then make the offers compliant with this section as well as the senior manager exemption? So in this case, you only need to comply with one. So if you've got someone who is a senior manager, then it's probably going to be easier for you just to rely on the senior manager exemption and not really worry about these rules in relation to those senior managers, in which case you can just kind of ignore the application of these rules for those people, because then you can rely on the senior manager exemption for those people. And so that's completely fine. However, if you set up your structure of your ESOP in a way that you're always just complying with these rules and someone happens to be a senior manager, then that's fine as well. You can use these rules in relation to them. But I would say that in the first instance, if you know that they are a senior manager, then it's probably just easier not to think about these rules, because then you don't need to worry about things like the monetary cap in relation to their offer.
A question also just came through asking if ESOP plans under this new division need to be registered with ASIC, and no is the answer to that question. You just need to include that statement in the initial offer document that the intention is that these offers will be in compliance with the new division, but you don't need to be registering anything with ASIC specifically.
And there's also some questions around how do you structure the kind of exercise periods for employees, and if you've got limited exercise dates, what happens if you want an employee to exercise when they leave? And so those are definitely the kind of complexities and nuances that come with thinking about how you want to administer your plan. And so, yes, if you do have an option plan that generally says, look, we only want people to be exercising, say, at the end of each financial year, but you also want people to exercise, say, if they left the company, then that unfortunately does introduce additional complexity, because then you need to make sure that you are providing those simplified disclosure documents prior to when they exercise, prior to when you tell them that they have to exercise their options, that you give them that sufficient 14-day period before they have the right to exercise around the time that they leave. So yeah, it does introduce additional complexity, and so that's something that the team in your company that's managing your ESOP would have to be conscious of, and it may be the case that you do manage exiting employees in a different way. So you tell them that they have to exercise, but maybe they still have to exercise in that set period at each year, and it might not be exactly when they leave. And so yeah, there might have to be some finessing as part of your administration of the plan to make it a little bit easier. But yes, it is complicated. Okay, I think we might leave it there actually, because there's a few other questions, but some of them don't strictly relate to the content of this presentation. So if you are people that ask those questions, including some about how to communicate ESOPs generally to employees, and some of you had some specific tax questions as well, absolutely feel free to book in a consultation with our team where we can chat about those questions in a bit more detail. Okay. So yeah, thanks so much, everybody. As we mentioned at the top, please feel free to fill in the survey. Your feedback really helps us and ensures that these webinars that we're presenting going forward are suitable and address the things that you'd like to. And then, yes, please include your contact details as well to receive a complimentary consultation.
Thank you.
Thanks, everyone. Bye.